This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to explain why a pro se plaintiff's Qui Tam lawsuit failed and why a private citizen may not, at least in the United States, compel enforcement of a criminal law. Ronald Rothman appealed from an order of the district court dismissing his complaint with prejudice and remanding a foreclosure proceeding to state court. In a case entitled Ronald Rothman v. CABANA Series 4 Trust et al., a United States Court of Appeal for the Third Circuit's decision of April 2, 2024, the Third Circuit resolved the disputes between the pro se plaintiff and the multiple defendants, including various banks. In June of 2023, Rothman sued the defendants, alleging that the defendants violated federal, civil, and criminal laws in connection with an invalid mortgage loan. Rothman claimed that the loan was obtained by his son in 2006 to finance the purchase of a property from Rothman, and that the notice of settlement for the loan was improperly recorded, and that the defendants illegally collected or benefited from insurance payments on the invalid loan. The action was based on the False Claims Act and numerous criminal statutes, including the RICO Act. Rothman sought declaratory judgments nullifying the mortgage loan and the sale of the property and requiring restitution of the insurance payments. In July of 2023, Rothman filed a letter with the district court seeking to remove a 2022 foreclosure action which stemmed from an alleged default of the mortgage loan from the New Jersey Superior Court Chancery Division to the District Court. In a memorandum order entered July 31, 2023, the District Court granted Rothman's motion to proceed in forma pauperis, that is, as a pauper, without any money, and screened and dismissed the complaint with prejudice pursuant to 28 U.S.C. Section 1915E2B. Appellees, the banks, and other defendants contend that the Third Circuit's lacked jurisdiction to review the order, remanding the foreclosure matter to the state court. The complaint was not a notice of removal, but rather an original action, and the district court appropriately treated it as such. In its memorandum order, the district court considered the claims and dismissed them. That determination was final and was reviewable by the Third Circuit. A district court cannot prevent appellate review of a final order by contemporaneously remanding a case to the state court. Rothman's complaint sought to hold defendants civilly and criminally liable for insurance fraud. Rothman claimed that the suit was in the public interest because the defendants were depriving the American public and citizens of the federal funds. The Third Circuit agreed with the district court that Rothman, in essence, asserted a false claims, Qui Tam, or whistleblower suit. In such cases, the government is the real party in interest, and although a private person, the relator, may bring the suit on behalf of the government, circuit courts agree that a pro se litigant like Rothman may not, nor could Rothman as a private citizen compel enforcement of the criminal law. The district court properly dismissed the complaint, and its judgment was affirmed. In my opinion, Qui Tam lawsuits are powerful tools against insurance fraud. However, as the Third Circuit made clear, a private citizen acting in pro se may not, nor may a private citizen compel enforcement of criminal law. This case established the old saying that he who represents himself has a fool for a client. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you will receive notice of every blog posting, usually 5, sometimes 6 a week, and you will have access to the more than 4,750 blog postings. You can also subscribe to these videos on rumble.com and youtube.com, and if you do, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com. And please tell your friends and colleagues about these blogs so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.